Okay, so moving on to a couple other forms of immigration relief that we see young people being eligible for are two things that are called UNT, non-immigrant status, but that everybody refers to as U visas and T visas. And these also come from the TVPRA, the Trafficking Victims Protection Reauthorization Act. Okay, T visas. T visas, in short, are for victims of human trafficking. And this means that that the child or the individual needs to comply with reasonable requests from law enforcement and assistance in the investigation or prosecution of human trafficking, except if you're under the age of 18. The law is very clear that if you are under the age of 18 and you've been a victim of human trafficking, you do not need, they don't expect you to be willing to testify in court and to be willing to actively be involved in the prosecution of your trafficker. You do need, however, to demonstrate extreme hardship, basically showing that severe harm would come to you if you were forced to return to your country of origin. The certification here, meaning the sign-off from the state or the federal officials who are investigating the prosecution of the trafficking, it's recommended, but it's not required. I've had a couple of T visa cases in my past job, and we didn't have the certification, and those cases were approved. So demonstrating that you tried to get the certification, a chain of emails from your discussion in terms of with that authority, that can be enough, and I'm happy to talk more about the specifics of that. U visas. So U non-immigrant status is for victims of crime. This crime needs to have happened under where the U.S. has jurisdiction. We often get children who have had horrible things happen to them on the journey to the United States. In Mexico, for instance, they can't apply for a U visa in the United States for bad things that happen to them in Mexico under how the law is written. So the victim, the child here, must have suffered substantial physical or mental abuse as a result of having been subjected to what's called qualifying criminal activity, must have information concerning that activity, and must help law enforcement in investigating and prosecuting the criminal activity. So here, the certification from the law enforcement agency or prosecuting authority is mandatory. You cannot get a U visa case approved if you don't have that sign-off. Don't send it in, they'll just reject it and send it back to you, probably with a nasty note saying, try again. So here, it's very important, and we can help with advocacy in terms of dealing with police officers who sometimes are very friendly at signing U visa certifications and sometimes not, and also dealing with the family courts, some of which have established protocol for signing U visa certifications, but some, especially further out in the counties that are further from New York City, might not be savvy, might not be terribly knowledgeable about the whole U visa certification process. And we're happy to help you to speak with them as well. Okay. Okay, and so here's just a sort of comparison checklist on T visa versus U visa. So both a T visa and a U visa enable the child after a certain amount of time, of 3 years of holding U non-immigrant or T non-immigrant status, of being able to apply for a green card, and then 5 years later being able, once they're 21 also, I'm sorry, yeah, once they're over the age of 18, being able to apply for U.S. citizenship. Okay. And finally, there's other areas of immigration relief for children and for adults as well. But one that we see often, or that we're starting to see as well, is something that's called prosecutorial discretion. So prosecutorial discretion has always been part of our immigration law and part of the law of any government agency. It's allowing the agency to make a determination. And so for prosecutorial discretion, oftentimes we're using this as a remedy for children who there is no other legal immigration relief possible at this time. We're all hoping for immigration reform, right? Or most of us are, and we're hoping that children, that the children that we're seeing might be able to benefit from different forms of immigration relief. But the immediate urgency right now is that this child is in removal proceedings, which means deportation proceedings. And we need to do something to get those proceedings either administratively closed or preferably terminated so that the government is not actively trying to deport the child. So where we've had successful requests for prosecutorial discretion, which is essentially a memo to ICE, which is the Immigration and Customs Enforcement, which is part of the Department of Homeland Security, asking them to join you in a motion to the immigration judge to either administratively close or to terminate the child's removal proceedings based on positive factors weighing in the child's favor. Where we've seen these cases be successful is when children came to the U.S. under the age of 16. So, for little people who have been here a long time, have continually resided in the U.S. for at least 5 years, been in school, graduated from high school, and so we have all these things. And what we're listing here is actually, as I'm reading this, in terms of children who are eligible for something that is a form of prosecutorial discretion that's called deferred action for childhood arrivals. So for those young people under the age of 16, they have had to, our slide's a little off, but they've had to have come to the United States I believe it's June 15th of 2007. So what we're seeing is children who have been here at least 5 years. So these are not oftentimes these are not the children who have just crossed the border, but these children do end up sometimes in removal proceedings because they've been apprehended. Perhaps they were in a car that was being driven by somebody, or they themselves were driving a car, the taillights were out and they were picked up and then turned over to immigration. It happens, we see it every day. So this does come up where children have deferred action for childhood arrivals, DACA, available to them. And then, sorry to be confusing, let me go back to the broader idea of prosecutorial discretion. So we've had those cases be successful, and those are for children who aren't eligible for this deferred action for childhood arrivals, DACA, for children who more recently came to the United States. Oftentimes, the younger the child is, the longer they've been here. Hopefully they're in school or they've obtained a GED. Usually these children aren't able to join the Army or to join the military because you need documents to be able to do those under the law right now, and clearly that the child does not have criminal issues. If there are, that's something we can discuss, but the prosecutorial discretion cases we've seen that are most successful are for children who are your average kids really, but are living with mom and dad and don't have the ability to obtain immigration status through special immigrant juvenile status, and may not have a fear that rises to the level of an asylum claim of returning to their country of origin, or have not been severely persecuted as well, and none of the other immigration remedies apply. So what prosecutorial discretion and DACA really are is DACA leads to the ability to apply for employment authorization and with that to legally work in the United States. But prosecutorial discretion that's not DACA is like a Band-Aid basically that is able to administratively close or to terminate the removal proceedings for the child, meaning that case is not actively calendared, but it does not lead to a green card for that child. It does not lead to a visa for that child. It's not really a form of immigration relief for that child. It's a Band-Aid to stop the immediate deportation and ensure that that child doesn't receive a removal order, meaning an order of deportation to be removed to leave the United States, but to hopefully be that Band-Aid until that child is able to qualify for another form of immigration relief, whether that's through a change in life circumstances or a change in our immigration laws. Okay. And so what we put up here that is a bit small and a bit hard to read, and we apologize, is our flowchart of the Safe Passage project. So this is just sort of a review. We're in the summary review period now of showing how we screen children at immigration court. We have law students and attorneys, myself and Guillermo, to then review and finalize and meet with the law students and make sure that we have an assessment memo and that our cases are good to go. We recruit pro bono counsel, who I hope we have some of you sitting in the room. And then we assign law students to the case. We start to work with the child, help you set up your first meeting, and then are there right behind you as much or as little as you need us to be there to answer your questions, to help you facilitate communication with your child, and to hopefully enable that child to secure immigration status.